Good morning. I am Patricia Kovacevic, General Counsel and Chief Compliance Officer with Nicopure Labs. Thank you for joining us for the first ever webinar on FDA regulation of vaping products. We hope to provide you with useful information, and we also hope that this will only be the first in a series of webinars for your benefit. Today, I will provide you with an overview of FDA's regulatory authority over vaping products. We will discuss upcoming FDA regulation of vaping products. We will talk a little bit about the pre-market authorization of tobacco products. We will discuss what are product standards under the Tobacco Control Act. And I will answer questions sent to us in advance of this webinar. You can, of course, type in your questions. However, I suggest you wait towards the end of the presentation and then send your questions in, because some of them may have already been answered. At the end of the presentation, we will allow sufficient time for a live Q&A, and we will take some of your questions and answer them. But before we start, let me start with a little disclaimer. Nothing in this presentation represents legal advice in connection to the matters discussed. Also, this is a very complex subject matter, and therefore this is just a top-line discussion. Of course, many other laws and regulations apply to all of our businesses, to vaping products in general. This is strictly about the upcoming FDA regulation of tobacco products. Also, if you feel that you will have to comply with any of the Tobacco Control Act requirements, please do not hesitate to retain your own expert consultants, because this is a matter of great complexity. Well, without further ado, let's start with an overview of the Tobacco Control Act authorities given to the FDA. The President signed the Tobacco Control Act into law in June of 2009. The Tobacco Control Act gave FDA broad authority to regulate tobacco products under the Food, Drug, and Cosmetic Act. Thus, the Tobacco Control Act is actually an amendment of the Food, Drug, and Cosmetic Act. And it recognizes FDA as the primary federal regulatory authority with respect to the manufacture, marketing, and distribution of tobacco products. So, under the Tobacco Control Act, what are tobacco products? Any product made or derived from tobacco that is intended for human consumption, including any component, part, or accessory of a tobacco product, with some exceptions, such as raw materials other than tobacco used in manufacturing a component, part, or accessory of a tobacco product. That's part of the definition in the law. However, the term tobacco product does not mean an article that is a drug, a device, or a combination product under a different section of the Food, Drug, and Cosmetic Act. FDA currently only regulates a few tobacco products, but it will regulate vaping products soon. Currently, the Tobacco Control Act applies only to cigarettes, cigarette tobacco, roll your own tobacco, and smokeless tobacco since 2009. However, the Tobacco Control Act empowers FDA to regulate other tobacco products by issuing regulation or rules. Also, in 2010, a federal court ruled that FDA cannot regulate electronic cigarettes as drugs or devices, but must regulate them as tobacco products. Therefore, we are now expecting the FDA to pass regulation that will cover vaping products, but also hookahs, nicotine-containing gels, and virtually all kinds of products that contain nicotine derived from tobacco or some other derivatives of the tobacco plant. So let's recap. Again, why are vaping products tobacco products under the Tobacco Control Act? Well, let's revisit the definition of tobacco products. Any product made or derived from tobacco which is not a drug or a device. Thus, for vaping products that do not make drug or device claims, and which contain nicotine or other ingredients derived from the tobacco plant, FDA takes the view that these products are tobacco products. So what's the status of FDA's deeming rule? As of this morning, it hasn't been published yet. Let's look a little bit at the history of this rule. In April of 2014, FDA published a proposed regulation, and a docket was open for comment. The docket closed later in 2014, and a lot of comments were submitted to that docket. FDA has reviewed all of the comments and prepared what's called a final rule. The final rule passed the Office of Management and Budget Economic Impact Assessment. Well, Nicopure Labs were the first to get a meeting with the Office of Management and Budget. The final deeming rule will be published in the Federal Register any day now, and then it will become final. Legal challenges or lawsuits may be filed to challenge certain provisions of the rule, but only if there is a legal basis to do so, and only by interested parties. This may delay the implementation of some or all parts of the rule, but please don't count on it. Well, let's visit some of the basic Tobacco Control Act requirements that are applicable currently to tobacco products and will be applicable to vaping products as well once the deeming rule becomes final. Everybody's saying usually, well, don't we have to wait for the deeming rule to be published to understand what we have to do? Yes and no. All the deeming rule does is to say, from now on, these additional products, including vaping products, are tobacco products, and therefore they have to comply with known requirements of the Tobacco Control Act. We've known these requirements since 2009, when the Tobacco Control Act was adopted. Most requirements are the same for current tobacco products, such as registration with FDA of manufacturing and importing facilities. Manufacturers or importers must file with the FDA a listing of their products and also representative samples of their marketing and packaging materials. Manufacturers or importers have to provide FDA with a list of ingredients. They have to provide a list of the harmful and potentially harmful constituents in vapor, but those will have to be defined at a later time. Also, modified risk or modified exposure descriptors such as light product, safer than, or does not contain X cannot be used anymore once vaping products are deemed. There is also a prohibition against adulteration and misbranding. There will be a requirement to have health warnings on packs. Those must be, however, specific for the nicotine-containing products. We believe that FDA will restrict the sales to only persons older than 18 years of age. Also, FDA will announce when they start inspecting manufacturing and importing facilities, as well as retailers. The manufacturing and importing facilities are going to be more thoroughly inspected. For retailers, the inspections usually refer to age verification and also occasionally to counterfeit product. In the proposed rule in 2014, there was a ban on free product sampling and also a proposal to restrict vending machines. However, we do not know if these are going to remain in the final rule. Finally, and most importantly, some form of pre-market authorization should be filed with the FDA, most likely within 2 years from the effective date of the rule. But this, again, will be subject to the final rule. In order to file such pre-market authorization requests or reports, there is the need to put together usually a team of experts that basically will go over the research available and will advise the respective companies on the applications. These are very complex and comprehensive, and FDA asks for a great deal of information in order to authorize new products. Apologies, I think we're trying to move the page forward. It takes a second. So, let's talk a little bit about the pre-market authorization of tobacco products that will be applicable to vaping products as well. The pre-market authorization requirement applies to any products introduced on the U.S. market or any change to a product that was on the market on February 15, 2007. Because all vaping products were in fact introduced to the U.S. market after February 15, 2007, therefore all vaping products are new products and will require some form of pre-market authorization within a certain time from the deeming rule. We don't know what that time is. In the proposed rule it was 2 years, but that may change. Generally, manufacturers and importers must submit an application to the FDA and receive approval before introduction into interstate commerce or marketing the product, as FDA calls it. However, there will be a grace period for products already on the market, probably 2 years, as I mentioned before, but we don't know yet. Once those 2 years lapse, however, manufacturers and importers will have to file some form of pre-market application with the FDA. The Tobacco Control Act provides for only 3 approval pathways. The first one is called, or abbreviated, the PMTA, the Pre-Market Tobacco Authorization. I also call it the new product or full pre-market authorization because it's really the most comprehensive application that a manufacturer may need to submit to the FDA. Section 910 requires pre-market review and authorization of new tobacco products unless FDA determines, after reviewing a different type of application called a substantial equivalence application, that the product is substantially equivalent to an existing tobacco product. So far we have 2 pathways. It's either an entirely new product or it's a product that can be compared to an existing product and it's found to be substantially equivalent. The third pathway is really a variation of substantial equivalence. It's called a minor modification exemption, but that's a very limited pre-market approval pathway. You can only follow that pathway for changes in additives, increase or decrease in the quantity of an additive. And because it's so limited, in fact, it was only followed in very limited occasions until now, and it will not be applicable to vaping products in the first stage. So, let's recap. What's a new tobacco product? A new tobacco product is any product introduced into interstate commerce after February 15, 2007. Now, you will hear talk about a grandfather date. That's the grandfather date. If a product is on the market, or was on the market rather, on February 15, 2007, that product is considered grandfathered. Of course, no vaping products were on the market in 2007, and even if they were, they would have changed since, and therefore, in fact, they became new tobacco products. So a new product is any tobacco product that was not on the market on February 15, 2007, or that was changed, however slightly, and that includes a change in design, component, part, constituent, or even in the content, delivery, or form of nicotine, or of any other additive or ingredient. So basically, any modification, however slight, renders a tobacco product a new product. This is important because going forward, even if a product in the future, a vaping product, receives a pre-market authorization from the FDA, any change to that product results in a new product, and that new product cannot be sold before FDA issues a pre-market authorization or a marketing order under one of the 3 pre-market authorization pathways. Let's talk a little bit more in detail about 2 of the 3 pre-market authorization pathways that might be applicable to vaping products. The more complicated one is the PMTA, the full or new product application, under Section 910B. Well, that is a very onerous pathway. FDA, in fact, has issued guidance back in 2010 describing what it expects to see in PMTA applications. And to this date, only one type of product, a snus product, in different versions, has received a PMTA order. The manufacturer of that product submitted in excess of, I believe, 120,000 pages of clinical research and all kind of product information and other kind of data. And that was a very well-researched product. And only after about 2 years did FDA grant the pre-market authorization for that new product. So it's a relatively unexplored pathway and by far the most onerous one. Now, with this type of application, FDA must act within 180 days of receipt of the application. It can reject or approve it. However, FDA can also reject the PMTA application right off the bat, right away, through what they call a refuse to file letter, if FDA considers that the information submitted is not nearly sufficient to even grant the need for FDA to review that application. So the fact that an application has been filed doesn't necessarily mean that FDA will sit on it for 180 days and will hear back in 6 months. Doesn't really buy us any time. Anybody who submits an application is well advised to, in fact, do a very thorough job and to file a proper application following FDA's guidance. The second pathway, the substantial equivalence pathway, starts by filing a substantial equivalence report with the FDA. And generally, that report needs to submit a detailed basis for determination that the product is either basically identical with a product that can be demonstrated to have been on the market on February 15, 2007, or with a product that has already received some form of FDA pre-market authorization. These are called predicate products. And also there is additional information that needs to be submitted, such as what actions the manufacturer has taken to comply with any applicable product standards. Well, even if a predicate product existed for vaping products, even if we assume that there was a product on the market on February 15, 2007, and to our knowledge there is none available, but even if there was one, the type and amount of information that FDA requires about that predicate as part of the substantial equivalence report is so detailed and so granular that it is likely that this kind of information would only be available to the maker of that 2007 grandfather product. So therefore, the substantial equivalence pathway is really not currently available for vaping products. More importantly, FDA is going to be very careful to require the comparison between the two products to be very detailed, and so much more we need to know full information about the predicate product. What is substantial equivalence? It's very difficult to provide any other definition but just the legal definition. And bear in mind that FDA really has interpreted this definition in different ways over time, over the last 6 years. Basically, a product is substantially equivalent with a predicate product if it either has the same characteristics as the predicate tobacco product, really exactly the same, it's virtually the same product, or has different characteristics, whether it's a difference in material, ingredient, size, and at the same time, it does not raise different questions of public health in FDA's determination. Now, of course, FDA has great discretion to assess what, in FDA's sole discretion, constitutes different questions of public health. Sometimes a difference in an ingredient can be a different question of public health, if that other ingredient is maybe questionable. So FDA will have to review the applicant's materials submitted to the FDA. They will normally ask questions and finally will issue a marketing order. The marketing order is usually accompanied by a technical memorandum where FDA explains the basis for their substantial equivalence decision. To date, several substantial equivalence orders were issued for conventional products, but with one exception, all were for rather trivial changes between the predicate product and the new product. The review process lasted usually in excess of 2 years. And also bear in mind that FDA really has no deadline to review substantial equivalence reports. However, During the review process, FDA usually imposes strict deadlines on manufacturers to answer FDA inquiries in connection with the reports that the manufacturer submitted for review to the FDA. For more information, I strongly advise you to visit FDA's tobacco products website and familiarize yourself with the information under Products Guidance and Regulation. There is a wealth of information, and it's best sometimes to use this as a starting point for your education. In conclusion, the Tobacco Control Act requires some form of pre-market authorization for all tobacco products, and therefore those requirements will be applicable to vaping products once they're deemed tobacco products. Well, does this mean that right after the rule is issued, all vaping products should be taken off the market? No, but FDA will allow a period of time for all manufacturers or importers to file some form of pre-market authorization as a precondition to keep the vaping products on the market. We believe this grace period may be as long as 2 years. However, this remains to be seen when the final rule is published. There will be other deadlines, of course, for submission of the other information to the FDA during that period of time. Once the deeming rule is published, we will organize another webinar and we will discuss the details of the deeming rule as applicable to vaping products. In general, FDA also has some useful educational resources in the form of webinars, and many of them actually are geared towards small businesses or towards retailers. Most of them are archived and they can be seen on FDA's tobacco products website under Compliance Enforcement and Training. I suggest you visit that website and try to view some of the webinars that match your interest area. Well, now let's turn to a topic that we've heard about in the media and certainly in certain trade shows, and those are product standards. What are product standards under the Tobacco Control Act? In day-to-day language, product standards can mean a lot of things. However, under the Tobacco Control Act, there is a very strict definition of product standards. Under Section 907 of the Tobacco Control Act, FDA has authority to issue product standards, which could include, without limitation, standards relating to nicotine yields, reduction or elimination of certain constituents and ingredients, testing requirements, and virtually any other aspect of tobacco products. And in the same manner, under Section 907, in the future, once vaping products are deemed tobacco products, FDA can also issue product standards for vaping products. However, under the law, FDA cannot ban categories of products and cannot require the nicotine yields to go down to zero. To issue product standards, FDA must engage in separate rulemaking, and there will be an opportunity for comment. That will typically involve first a notice of proposed rulemaking, the comment period, and only afterwards the issuance of a final rule. Therefore, do not expect anytime soon a final rulemaking on construction, content, and flavors in vaping products. That will take time to elaborate. Also, because FDA is a science-based organization, FDA has to base these standards on the best available science and also has to take into consideration any side effects of these product standards. However, FDA has another powerful tool to take off the market products that contain ingredients or perhaps vapor constituents that FDA is not in agreement with. FDA can and will reject pre-market submissions for new and even for existing products if FDA in its sole discretion believes that the applicant has not submitted sufficient information about the product or if the authorization is not appropriate for the protection of public health. The public health standard is really a novel standard and it's only applicable to tobacco products. FDA regulates drugs and devices in a very different manner. Now, let's turn to some of the questions that some of you sent us in advance of the webinar. Thank you very much for sending those questions because it really helped us inform what the content of the webinar should be to be more interesting to you all. So what will happen after the day when the deeming rule is passed? The first day, nothing will happen. The deeming rule will provide for certain deadlines for compliance with certain sections in the Tobacco Control Act. Some may be shorter, 6 months, for instance, for product listing and for ingredient submission. Some may be longer, 2 years. In the meantime, it's business as usual. We will continue to sell our products and we will all start working towards compliance. How long will it be between the deeming rule is announced and when it becomes effective? It's usually a 30-day period. However, it could be slightly longer, and that will be stipulated in the text of the deeming rule. Does FDA regulation affect pricing? No, FDA does not have authority to impose limits on pricing. And what about taxation? Again, FDA has no authority over the taxation of vaping products. We will not discuss state or federal taxation of vaping products in this webinar, but we might organize one in the future if that topics become of interest. Can FDA set minimum age to purchase e-cigs or other vaping products? Yes, and we believe it will. We believe that age will be 18. How can FDA regulate advertising, sampling, uses of logos on merchandise, and so on? FDA can regulate those through rulemaking. However, FDA would have to engage in separate rulemaking to prohibit or limit the advertising of vaping products. Please bear in mind that attempts to limit the advertising of conventional tobacco products through a separate rule, in fact, were challenged in court under the First Amendment, and those challenges were successful. So bear in mind that there is usually heightened scrutiny over attempts to limit freedom of commercial speech. Can FDA issue regulation regarding packaging? Of course, and it might. However, regulation regarding packaging can, I should say legislation regarding packaging, can be introduced separately by Congress, and we believe that this is an initiative that could happen in parallel. For instance, child-safe packaging. How will or how can FDA regulate the manufacturing processes? FDA inspects manufacturers, and it inspects manufacturers usually based on FDA's experience with other regulated products. They look for processes, they look for quality control, sanitation, and the like. FDA can also issue good manufacturing practices, but to date it has not done so for tobacco products, although we know FDA has often spoken about good manufacturing products being in the works. Therefore, we believe that those will come through a separate rulemaking in the future. And the next question is related. Are there any today? And no, there are no good manufacturing practices today. But yes, you may need to invest in your facility in order to comply with good manufacturing practices. There will be, however, a grace period and a reasonable deadline to allow manufacturers to comply with these good manufacturing practices. And when will FDA inspect manufacturers and retailers? Well, FDA will announce when it starts inspections. However, those inspections are completely unannounced, and they can be regular inspections or inspections for cause in case there is any complaint that is meaningful about the product. There could also be inspections if a facility was closed by the FDA before resuming operations in that facility. Usually FDA has a 2-year cycle of re-inspecting the same facility, and to date, conventional tobacco products manufacturers have already been inspected many times, and copies of the inspection reports are generally available. How much longer can I sell my products after the rule if I cannot meet FDA requirements? As I mentioned before, everybody has to comply with different requirements, and when FDA inspects a particular facility, it would also look at compliance with the various requirements. So for instance, if a manufacturer does not register its facilities, and let's assume the facilities were due to be registered 6 months after the adoption of the deeming rule, when FDA inspects a facility, it will find that the facility was not registered, it may tell manufacturers that they cannot sell products any longer. Same with other requirements of the Tobacco Control Act. So the key there is compliance. As long as you comply with the deadlines in the rule, you will be fine. And as long as you comply with the filing deadlines for the pre-market authorization, you will be fine. However, when FDA reviews the pre-market authorization for a particular product, if it does not approve it, it will issue an order for that product to be taken off the market. Realistically, if you comply with the other requirements other than pre-market authorization, you are likely to be able to keep your products on the market for however long it takes before FDA reviews your pre-market application. Will FDA ban flavors? FDA has the authority to issue product standards limiting or banning certain ingredients through Section 907 rulemaking, as discussed before in the section about product standards. However, FDA would have to first issue such rule, and we do not believe that in this rulemaking, the deeming rule, there will be anything banning flavors. FDA, however, has the authority to not approve products for which pre-market authorization applications were filed because of a certain ingredient. And that will be something that FDA will judge on a case-by-case basis, reviewing the ingredients of every product before FDA. So FDA has indirect tools not to allow products with flavors, but in order to specifically ban flavors or ingredients, it would have to engage in rulemaking. How long does FDA take to review pre-market applications? Well, it depends. The simpler the application, the shorter the time, but historically it took FDA quite a lot, at least probably a year and a half to 2 years, to review the pre-market applications that received marketing orders. If FDA wishes to reject an application off the bat, it will do an administrative review, and it may actually issue a negative finding very quickly. Well, you may ask FDA if they can certify or approve your products, but just so you know, there is no such thing as a certified or approved tobacco product. That's specifically not authorized in the law, and you cannot make that kind of statement. Will the FDA endeavor to identify or record illiquid manufacturers? It is the obligation of the manufacturers and importers to register themselves with the FDA once vaping products are deemed tobacco products, and FDA will set a deadline for that. The registration process is very simple. It's a form that's online, and FDA will provide ample instructions as to how to do that. Will importation of non-conforming e-liquids and hardware be banned? Yes, of course, like with all tobacco products, if the importers do not comply with the registration and all the other requirements of the Tobacco Control Act, of course, products may be seized upon importation. Will there be limits on the number of SKUs allowed? No, but bear in mind that pre-market applications can be very costly, and therefore there may be a natural limit on how many applications any particular manufacturer can file. Will regulations impact hardware or just the liquid? We believe that it is reasonable to expect that FDA will try to regulate hardware, that in fact regulation will be applicable to hardware as well as an accessory. But again, we need to see the text of the final rule to be certain. Will the criteria be different for big tobacco versus smaller manufacturers? The short answer is no. With few exceptions, small enterprises are not really granted any kind of favors by the FDA. So it will be, in that respect, a level playing field. Will FDA regulations supersede or replace state or local regulations? And the short answer is generally yes. There is a preemption clause in the Tobacco Control Act, which means that the FDA has primary authority over tobacco products. However, the states will still be able to regulate the manner and place of sale of tobacco products, and they will still be able to regulate taxation, vaping bans, and vaping age in their respective states. With respect to manufacturing and labeling of tobacco products, FDA will be the sole authority, and therefore we will not see any more different states imposing packaging and manufacturing requirements once the deeming rule is adopted. Can states add additional rules and requirements to FDA regulation? No, but as I mentioned before, states can still regulate the manner and place of sale. So just to give an example, the manner of sale would be, for instance, states can require that all vaping products be placed behind the counter or even under the counter, and or try to exclude certain types of vaping products from sale in the respective state. What can be done to oppose FDA regulation implementation? First and foremost, you have to have a basis to do that, and you have to be an interested party. And therefore, I believe everyone that believes has an interest should consult with their attorney and look into that. Finally, I've already received a few of your questions, and I'd be very glad to turn to them. So one of you is asking about fees, about manufacturers needing to pay fees to register each flavor and each nicotine strength. That is absolutely not true. There is a fee that manufacturers have to pay, but those fees have not been quantified yet for the vaping industry. And currently under the Tobacco Control Act, what they call the user fees for the operation of the FDA are split among manufacturers of conventional tobacco products. However, at some future, there might be a small fee allocated to vaping products. We do not know yet. It is not clear how that would operate, and it's likely proportional to market share. Therefore, we do not think it would be high. Again, there is no guidance as to those kind of fees at present, and therefore they're not due. What will online retailers have to do to comply with retail inspections? That's a very interesting question, and more than one of you have actually asked it. Thank you for that. So, as you probably know, conventional tobacco products are actually not sold online. So when we talk about retailers for conventional tobacco products such as cigarettes and smokeless, we really only speak about brick and mortar retailers because that's the only place really where legally products are currently being sold. And therefore, FDA will have to come up with guidance for online retailers, such as ourselves, Halo 6, and others. Age verification is, of course, the question on everybody's mind, but we do not know. We have to wait for the final rule and also wait for FDA guidance to make sure that we comply with any age verification, if applicable, for online retailing. Of course, FDA can inspect by simply trying to access the online retail page and try to understand how the retail procedure works. Another question is, if you have a liquid manufactured on the private label by another manufacturer, would the seller of the liquid be bound to submit applications for their brands? Well, it depends on what your contract with that manufacturer says. Generally, it's the manufacturer, but if you're labeling your product, you may be identified as a manufacturer, and you may be also the one providing the design, in which case both of you should register and both of you should be inspected. Again, this is a matter that generally you have to review with your consultants, but I would say generally expect that both the private label owner as well as the manufacturer of manufacturing facility will be inspected, because the private label owner may provide marketing guidance, design guidance, ingredients formulation guidance. There was a question that states that there was that somebody states that there are electronic cigarettes on the market in 2007. The date is February 15, 2007. So actually, the product itself has to have been on the market not before, not after, but on February 15, 2007. You also have to be able to demonstrate that. And you also have to be able to send to the FDA a request for what they call grandfather determination with supporting information that demonstrates that the respective product has been on the market on February 15, 2007, and it hasn't changed since. And yes, if a product was on the market on February 15, 2007, and it's still being sold without absolutely no change, of course, you can continue to sell it under the Tobacco Control Act. But be aware that FDA is not naive, and they will investigate and submit, and they will scrutinize the way the product is manufactured. And you will have to demonstrate, even if the product is made in China, that the product is being made in the exact same way like it was back in 2007. I doubt that is possible. My understanding is that a lot of the parts and accessories, batteries, coils have in fact changed, and you may not be able to demonstrate that. So again, I wouldn't necessarily count on it. Another question has to do Another question says, we have heard that no E6 product made in China would be allowed. That is absolutely not true. A product can be manufactured anywhere. In fact, most drugs currently sold in the US are made outside of the US, and many of them in China. FDA even has an office in China, and it actually inspects drug and device manufacturers in China routinely for a very long time. Therefore, FDA can and eventually will inspect China-based manufacturing facilities. Of course, if a product is made in China but it doesn't have the necessary paperwork, if the importer has not complied with the requirements of the Tobacco Control Act, it will be taken off the market because it's not compliant, not because it's made in China. Again, FDA does not have a bias against foreign manufacturing. A lot of other FDA-regulated products, foods, cosmetics, drugs, devices are made in China and elsewhere in the world. The other question has to do with international inspections. And it's really misstated. It says, because it is not possible to inspect international mail going to customers, does that mean that foreign online retailers will take over the market? This is an excellent question. And let me tell you what happens with conventional tobacco products, and you may find analogies. If you go online at any given time, you will find a wealth of websites advertising sales of cigarettes from overseas. And let me tell you, all of them are actually engaging in illegal sales in the US. FDA is routinely sending warning letters to those websites for conventional cigarette products and is taking them down. In fact, FDA is very active in that. And if you go to FDA's warning pages, warning letters page on FDA's website, you will see that to date, FDA has issued numerous such letters to foreign online retailers of cigarettes, and it will do the same with electronic cigarettes. The reason that's going to be a little bit slower is because, again, FDA will be faced with a big volume of applications, with a big volume of SKUs that it has to become familiar with, and therefore that may take longer time. It doesn't mean necessarily that you have to sit idle. If you're aware of illegal websites targeting the US, FDA has a form on its website where, in fact, anybody can notify FDA of illegal tobacco products, and FDA will likely investigate if there is a good basis for that. So bear in mind, you're an active participant on the market, and it is up to us to police our own market and to work with the FDA. FDA can also be our ally, not only somebody to be feared. Couple more questions, and I believe we'll be almost up with our time. The question is that a lot of online manufacturers are from sites like Alibaba and DHgate, which sell gear from many different manufacturers. Am I responsible to understand whether a manufacturer is legitimate and get certification? Well, if the question is about parts that you buy in order to put together a device or to manufacture a device or hardware here in the US, the short answer is yes. FDA will want you to have some form of information about your supply chain, and most likely parts and pieces bought online, if you use them in manufacturing tobacco products or hardware, are not going to pass an FDA inspection. FDA really requires very good traceability of all incoming materials, ingredients, and parts of your devices. Again, this is a very comprehensive matter, and if you are indeed engaging in manufacturing of hardware for vaping products here in the US with parts that you purchase online, I would suggest that you consult with an expert in FDA inspections and in FDA good manufacturing practices, and they will guide you through the whole process. If you're a distributor, not a retailer or manufacturer, what rules are distributors bound by? Well, the good news is a distributor that does not engage in retail and who's not a manufacturer is not inspected by the FDA routinely. However, if FDA is investigating a particular product, or if a particular vaping product is subject to a recall in the future, of course, the distributor or wholesaler may be impacted. But wholesalers at present really do not have to do anything in connection with the FDA. It is also important, however, to know the manufacturers you buy from, because you really want to ensure that they comply with FDA regulation. And And it doesn't necessarily mean that you will need to do anything in particular. We believe that if you have a trusted relationship with the manufacturer, and if you see that they're active and engaged with the regulators, that's usually a pretty good indication that at least they care and try to be compliant. Now, another question is about user fees. Again, the user fees will be defined at a later date, and at present there is no guidance. Another question is, if my product is made in China, the China manufacturer will be responsible for filing the paper with the FDA. Is that correct? I, as a retailer, will not be responsible for filing with FDA. Well, you're really not a retailer. Most likely you're an importer. So if you're the one who brings the products onto the market, if you want to continue to sell them, it's either the Chinese manufacturer or the importer, but somebody's got to file. Even if you're only the middleman for the US, but you're the first person really to bring these products into the US, you're really responsible to follow the importer rules and do all those filings with the FDA. Again, I advise that you consult with a specialist because this can be a comprehensive matter. I would also, not necessarily rely that somebody from China will correctly file all the necessary paperwork. And bear in mind that the pre-market authorization is a very complicated matter, and companies have to have sophisticated resources to comply with that. Therefore, if you want to have the same continuity of supply chain, I would sort of take the matters in my own two hands, if you know what I mean. If we can scroll up a little bit, please. Yeah, I believe that we've answered most of the questions. Some of them are repeating, but yes, let me throw another question at you. So another question is, what happens at customs if I have vaping products coming from outside of the country? So in the first period of time, of course, nothing will happen, but bear in mind that FDA has a presence at customs, and that FDA is basically very familiar with inspection of regulated products. In fact, all devices and drugs that come into the country usually are pre-registered. So in fact, there is a very clear flow of the way inspections at customs go. Now with vaping products, it's going to take time for FDA to establish the necessary software and also the necessary procedure. So in the first period of time, we may see a little hiccups, but bear in mind that as long as you comply and as long as you have all the necessary paperwork as an importer, and you can demonstrate you have followed and met the deadlines in the rule and you have followed the Tobacco Control Act requirements, you should be fine. However, if at that time you encounter a problem at customs, of course you will have to work with them to solve the problems. The other question that I would throw at you is the following. Sometimes people ask me about the number of man-hours that is required to comply with all of these requirements. And in my experience, having been in this industry for a very long time, having filed and successfully filed actually the very first pre-market applications with the FDA that have been ordered by the FDA, I can tell you it always takes more than you actually think. More importantly, the resources don't only consist in man-hours, but also management time, and also the type and quality of people that work on the pre-market applications. Basically, the pre-market applications have a chemistry component, a toxicology component, an engineering component, a manufacturing component, an environmental component potentially, and therefore, bear in mind that you may need to use resources from all of these areas of expertise in order to put together pre-market applications. Are they impossible? No. Do I believe that it is feasible? Of course, and we believe that everybody can comply. Of course, it does require an effort and it does require good coordination. Another question is about fees associated to application. Again, I cannot repeat this enough. At present, there are no fees. If FDA will determine any fees, they will be called user fees, and they will be split most likely proportionally among participants on the market. But at present, there is absolutely no indication as to any user fees, and we do believe that additional rulemaking will be needed in order to define the amount of user fees. For now, only conventional tobacco products manufacturers pay user fees, and that is likely to remain like this for another period of time. And finally, will this webinar be available for viewing later? Yes, it will be available and we will place it on the halo6.com website and I will communicate it through our social media. Thank you very much for your attention and we look forward to seeing you at our next webinar. Goodbye.